This episode of AHLA Speaking of Health Law is brought to you by AHLA members and donors like you. For more information, visit AmericanHealthLaw.org.
Hello. Good morning, good afternoon, depending on when you're logging in. Thank you to AHLA for having DeAngelo and I here today. We're going to talk about strategic litigation and healthcare disputes. This session is based on our presentation at the 2025 In-House Counsel Program in San Diego. So it's a follow-on to that, and we're excited to be here today to continue this conversation with you. I'm going to toss it over to DeAngelo Norris, who is Senior Associate General Counsel at Grady Memorial Hospital in Atlanta, to introduce himself and tell you a little bit about himself as we get started. DeAngelo?
Sure. Hi, Emma. It's great to see you again, by the way. So as Amanda mentioned, I work at Grady Hospital in Atlanta, which is one of the largest trauma hospitals in the Southeast. And here we have a plethora of legal issues, everything from medical malpractice, premise liability, to guardianships. So I've been at Grady for 18 years. It's been a ride. I really have enjoyed it. And I really enjoyed our session that we had in San Diego. And I can't wait to get into some of the conversation.
Thank you. Yeah, great to see you again too. It was a nice discussion we had in person in San Diego. I'll just introduce myself briefly, and then we'll kind of dive into some questions and some follow-up.
Sure.
I'm a healthcare partner at King and Spalding in the Los Angeles office of King and Spalding. My healthcare practice focuses on representing providers, including hospitals, hospital systems, medical groups, other types of facilities, ASCs, laboratories, any type of provider in disputes, and primarily disputes over reimbursement issues with health plans. I've been with King and Spalding since 2018. Before that, I was also practicing healthcare law at a boutique firm. So lots of fun in healthcare. Just to kind of get us started, DeAngelo, can you tell us what kind of litigation matters, what kind of cases do you manage in your role?
Sure. So yeah, I kind of touched on a little bit in my introduction, but I think that when you and I spoke in San Diego, it was unique to see that you're outside counsel, I'm inside counsel, so it's kind of a balancing act. But some of the things that I deal with is giving advice and counsel to our executives, our C-suite, managing the employment issues that we have here, whether it's EEOC or alleged wrongful terminations or mass terminations. We also deal with a lot of premise liability, and we also manage outside counsel when it comes to our major medical malpractice lawsuits. We work with a team of outside attorneys to plan our defense strategies and to coordinate the legal operations. And we work closely with our risk management team, which is a part of legal affairs umbrella here at the hospital, as well as compliance and internal audit. That's the entire team that falls under the legal affairs division.
Wow, really the gamut, a lot of different things. Again, a lot of different topics can end up on your desk. And in your role as in-house counsel, in dealing with outside counsel, what are some of the best practices you've seen from outside counsel in terms of managing your high stakes litigation?
Sure. So I think one of the things that I can think of that comes to mind is the communication piece, which is making sure that whoever you have on the outside is communicating effectively with you about filings, about progress in the case, about the barriers that they may have dealing with people at the organization. Sometimes outside counsel will run into barriers and they'll just stop and not necessarily pick up the phone and call. So communication is key. And sometimes we've had, I think, issues where there's a new person assigned to the case by outside counsel, but they're not appropriately introduced to the inside counsel. And sometimes that can be irritating, or it can be something, an area of improvement. Um, I think the best outside counsels that I've seen over my 18 years are the ones that understand our mission. We're a public hospital, we're a teaching hospital, which is very, very unique. It means that our staff, the majority of our staff, they learn and they go out into the world, and we have, new residents coming in all the time. That they understand that part, and that our ultimate mission is to provide healthcare regardless of a person's ability to pay. And that has to match up with our litigation strategies and our goals overall.
Yeah, that makes sense.
Well, to kind of throw it back at you a little, Amanda, what do you
Yeah.
think you would like to see from inside counsel sometimes that you don't see from outside counsel? What would be some best practices or areas that inside counsel could probably benefit from if they knew about?
That that's a great question. It's a hard question because as outside counsel, that's your boss, right? Your in-house counsel is your boss, and you report to them, and your job is really, because obviously your boss, your inside counsel, who's managing the litigation, also has someone that they report to. So I think of, my job is to make them look good, and to help them accomplish their goals for the organization, and within the organization. But I just wholeheartedly agree that communication is key. I mean, that's kind of the cornerstone of a good in-house and outside counsel relationship. Keeping each other informed. Of course, the outside counsel, an important part of their role is to keep in-house counsel and the business folks, and whatever channels the organization prefers, abreast of what's happening with the litigation. But that communication also goes both ways. So learning new things about what is happening within the organization. And, an example comes to mind, a dispute I'm managing against a payer on behalf of a client. I didn't find out until it was done and dusted that the client and the payer, who we were in litigation with, were working on and signed and completed a contract. It would have been really great.
It's pretty important.
That because it had impact on the case. The terms of that contract had impact on the case. And we found out about it after it was already done. So things like that, I think, are, it all kind of goes back to communication and keeping those lines of communication open.
And if I could supplement my answer just a little bit, something I thought of when you were talking is I love when we have an outside counsel and they may send us some advanced sheets or something that we're working on. They know that we have a problem in a particular area. Like right now, we're looking at a lot of AI and things around AI. So we have counsels that will know, hey, Grady is looking to form a new AI, send me an article or send me some conference information. Even though we may not thank them every time they send it, it's very important. And we use that information, inside to say, hey, Amanda's thinking about us. She's sending us about our issues. And it goes a long ways when we have our internal conversations to push business back your way. So I think it works both ways.
Yeah. That's really good to hear, because sometimes you feel like you're sending stuff to clients and you don't know if it's useful to them or not because they don't necessarily respond back. But but it is good to know that it is often being used, even if there's not a reply.
Thank you. Yeah.
that we talked about in San Diego, and I always, find as an important part of kind of setting the table for litigation is the pre-dispute practices, and we talked a little bit about this. What strategies have you found effective in managing disputes, particularly on the front end and when you're in the pre-dispute posture, that can help you be successful as the dispute goes on, or maybe even get it resolved before it actually goes to court?
Well, one of the things I learned over time is to meet with your stakeholders internally first, like to kind of get a lay of the land, because sometimes there are unrealistic expectations or there may be just misinterpretations of what's happening in the dispute. So try to figure out, number one, who are the parties involved internally before we even reach out to outside counsel or before we reach out to the opposing party or the, first figure out who's involved. And the second thing I try to do is to figure out the expectations. I mean, what are we trying to do? What are we trying to accomplish? Like any good attorney should do is sit down and talk through those things before reaching out, and to see, obviously, if we have anything in common. Have we been working together before in other relationships? Are there other synergies we can work off of to help to resolve this dispute? And we also have an internal, that's in legal affairs, an internal risk management team. And a lot of times they have information in their systems, in their tracking systems, about trends, about other things that may be relevant to helping you to come to a resolution. Or it could be a similar dispute that has already been settled with someone else or in another situation. I always try to get that information up front before, and kind of have a game plan before I reach out. And also, one other thing I add before I close is that sometimes knowing who to approach on the other side, or who has kind of pushed this dispute to the point of, we're going to court, we're going to fight this, we're going to sue you guys. And there may be some soft spots in that area where you can make progress that someone else hasn't really, it's fertile ground for resolution sometimes.
Yeah. And you probably won't be able to find that out unless you are connecting with your internal stakeholders, because those are the people who know who the people are likely on the other side, right? That they may be in the best position to know who's kind of driving the dispute from a party perspective on the other side. So that might give you an opportunity to reach out and see if there's some way to resolve it before it goes to the next step.
Yeah, it's kind of like, what you learned in law school, the meeting of the mind. So at some point in this relationship, we had a mutually beneficial relationship. We thought that we were great partners. You were the fit, and we were working things out appropriately. And now something's come up, and sometimes it's not what you think it is. It may not be as simple as a legal answer. It may be something softer or something that's more personal that you have to kind of weed out and figure out how to reconnect these partners that were partners for a very long time. Whether it's, hey, we need to get rid of this person and get a new person, or maybe some hard conversations, but sometimes those things have to happen to progress to the next stage.
Yeah, I often find that that's exactly right. There are the business is run by people, and there are personalities always involved at different levels of a dispute. And so kind of figuring out whose motivations are where, what people care about, and what people, what's kind of driving their decision making, can help you potentially find a resolution. We talked about contracting when it comes to disputes, and we talked about this in San Diego as well, and how to effectively use contracts to help manage disputes on the front end. What are your thoughts about approaching contracting and how that interplays with dispute management?
So a couple of things that I think about when I think about this area is, one, I feel that if you have a lot of terms and contracts that are just really hyper specific, it can sometimes cause problems that are not anticipated when you write the contract. So I think that all contracts need to have room to breathe, although it doesn't necessarily have to be just an open contract, so anything can happen. I've found that determining where those areas where the parties can agree to be flexible are important up front, one. Two, we've used terms in contracts that have been very effective in the past, terms such as requiring the leaders of both organizations to meet prior to any type of even arbitration, mediation, or lawsuits being filed, to have them sit down. And that has surprisingly, well, probably not surprisingly, settled a lot of disputes. Just the CEOs of both companies talking and figuring out what is mutual understanding. We've even used in some contract agreements where we can't decide on the choice of law, we've used the term that it will be in the state of the non-moving party. So if I sued you, Amanda, I have to come to your home turf. And if you sued me, you have to come to Georgia. So that kind of puts just a little road bump if it's not a serious thing that needs to go to court. So those have been effective. What about from outside counsel? How do you view, when you look at contracts that are in dispute, how do you view those as far as resolution and ways to get to a resolution easier?
Yeah, something that you said really resonated with me about how if there are too many very complicated pre-dispute procedures, it can actually get in the way, or make things, present a kind of unanticipated challenges. But at the same time, requiring things like, a meeting of the stakeholders, of, high level executives at the company actually meeting to discuss the dispute, because sometimes when those people get in a room, they can figure out a resolution that maybe the rest of their teams did not take advantage of. But I often do feel like the dispute resolution provisions they're not the focus of the business people when they're making these contracts. They're focused on the business terms. They're focused on, the money within the contract. But these dispute resolution provisions can actually have a really big impact on the litigation itself in, a few different ways. Sort of just at the outset, do they require arbitration, or do they allow the parties to go to court? That can have a big impact, because sometimes, depending on the nature of the dispute, one party or the other may really not want the publicity. And they would really rather it be an arbitration, so they're not, necessarily going to be getting news coverage over that dispute. That works on both sides, because the one side that may know that the other side doesn't want the publicity has that leverage now, to say, I can take this to open court. There's no arbitration provision, and that can actually have a significant impact.
Yep. And I've also found, Amanda, that sometimes the disputes that I've dealt with in contracts, it comes down to the person that's trying to sell this business to the hospital saying one thing, and maybe the legal team or the team that wrote the contract is not really as involved in that conversation, because obviously the person that's here wants to make a sale. Their motivations are a little different than the people that really wrote the contract, and they understand the legal barriers to what the business person is trying to do. So you have to figure that part out first. Even sometimes we get contracts and the legal team to edit the contract is not even on the document. We have to find out who is your legal team. We don't want to talk to the person who sold this contract. We want to talk to the person who wrote the contract, who's going to be responsible for the legal terms of the contract.
Right. That makes a lot of sense. And then also, depending on the contracts, some contracts don't say anything in the dispute resolution terms about discovery. And then other contracts are very prescriptive about exactly what discovery can be done and what can't be done. Some will just refer to, if it's going to be a AAA arbitration, the AAA rules, or JAMS rules, something like that. But I find that often the contracts with very prescriptive discovery rules can cause challenges in the litigation if your discovery needs are different from what may have been contemplated at the time that the contract was entered into.
And also, we're against a lot of the evergreen terms, because a lot of times people change and the organization changes. So if you have these contracts that just continue on into perpetuity, you don't really have a chance. Even if you're going to go back with the same contract, it still is a good idea to put some kind of a provision that allows it to be renegotiated and terms to be updated. I think it makes it clearer, as opposed to doing these one-page amendments to continue a contract for 15 and 20 years without looking at regulations and compliance, things that have changed over the course of those 15 years. So
sometimes we see some really old paper, right?
Oh, yeah.
Really old paper that's just been evergreened and tinkered with from time to time, but really out of date dispute resolution provisions. And then another, I would say, another piece that often trips people up, and because they're not thinking about it necessarily being in the dispute resolution provision, but time bar term.
Yeah, that's right.
Those, as opposed to just state law applying, if the parties can contract for specific time bar provisions, and sometimes I've seen them be really, really short, and no one's expecting it, and the client comes to us with like, hey, we have this dispute, great, and then we get into the dispute resolution terms and there's a 6-month time bar.
And it's passed.
And that's a problem. So and sometimes the client just doesn't look there for that type of provision and doesn't necessarily know that that's there. So there's sneaky things in dispute resolution provisions, and it's really one of the first places I look in a contract is I get a contract from a client and start analyzing it. It's one of the first places I go, because I'm like, okay, what's the rules of the road here that we're dealing with, so that I can advise the client on kind of process and what our options are.
It's good. That's good practice.
Yeah, go ahead.
I was going to say, so to transition a little bit about going to trial. You want to talk a little bit about that, maybe?
Yeah. So yeah, if you've made it all the way through discovery and maybe a mediation and things still haven't gotten worked out, you're going to trial or going to arbitration. When and actually our team goes to trial and arbitration a fair amount. I'll be in a jury trial all of November, and then I'm off to another state for arbitration most of December. So we actually go a fair amount, but a lot of clients don't go very often. And so I think it's important to spend a lot of time leading up to trial with your in-house counsel, of course, but a lot of time with your witnesses, particularly if your witnesses are coming from inside the organization, because as you spoke at the top to your mission, hospitals are mission-driven organizations, and employees are focused on delivering that mission, delivering healthcare to their communities. And a trial is very distracting. It's not what they want to be doing. So, the care and handling of the witnesses, particularly if people are going to need to be coming from the hospital to testify, it's really important to kind of warm people up to, it's okay. It's not the end of the world. It's not that scary. These are just, arbitrators or jurors, and they want to know what you have to say. And spending a lot of time preparing everyone goes a long way, I think, to kind of reduce everybody's nerves.
Right, I agree with that. And with the witness prep, we try to have our witness prep here at the hospital, so it doesn't. It's not too inconvenient for the providers to come down to our office to do the witness prep and to actually be there for them, because you're right, they panic. I mean, as a teaching hospital, people are gone maybe in the 2 years when something comes up and they call him back. I'm filling out a new application, at a new hospital, and they're asking me about being in lawsuits. Have I been sued? What's happening? What should I put on this as a response? So they're really nervous. The providers are very nervous about being named. But what we try to explain to them is very rarely is it one person that did one thing that caused any bad result. And sometimes we have to sit down and have your piece to appropriately defend you and the other parties involved. And let's sit down and pull out your piece, parse out what you did or what you didn't do, and talk about it, and let us know, why you did what you did.
Yeah. From an inside counsel perspective, what are your expectations of outside counsel when you're going to trial?
I expect the outside counsel to, first of all, if they're going to be reaching out to witnesses or talking to someone at the hospital, to at least have an inside attorney involved in that first conversation with that person, so that we can make sure they're comfortable speaking with you and they know that you're an appropriate party to speak with, to kind of to tee it up, and it sets the tone for the relationship. That's the first thing I would say. I also expect outside counsel we have occurrence analysis or updates that we need on the case prior to, trial, prior to mediation, prior to arbitration. I expect those to be updated. So the posture of the trial, if it's changed any as far as our likelihood of success, we need to know that. If something is hasn't been discovered yet, but it may turn the case, it may be dispositive of what the issue is, I want to know that too. And it's important that outside counsel realizes that we obviously are here for our defense of our position, but we also are here to protect our witnesses who are our employees. So, in depositions, we don't like to see our employees getting beat up or treated unfairly. We expect you to advocate for them, as well as the hospital, but to not throw out people to the wolves, and to understand that, like you said previously, that we are a hospital and our main thing is to make sure people have patient care, health care, and it's appropriate, and it's not in the world or the field of litigation or lawsuits. That's foreign to a lot of people,
Yeah. All of that really resonates with me, and I find, as you mentioned, if you're communicating with outside counsel, communicating with a witness, for example, making sure to go through in-house counsel at least at the beginning. That's really important, because if you're talking to a nurse or a doctor or anyone else, someone who works in finance or managed care, they need to know from their internal people that I can talk to this attorney and this is okay, and I'm not, stepping out of line here or in trouble or anything like that, because sometimes it's scary to hear from an attorney if you're, just someone doing your job, and it goes a long way to have that warm connection between the in-house counsel and outside counsel and maybe a potential witness or something like that. I completely agree with that. In terms of experts, how do you typically like to handle expert witnesses? We talked a little bit about this before. And your expert needs, maybe in the kinds of cases you manage, maybe a little bit different from the kinds of experts that I use in my cases. But how do you approach working with outside counsel to identify experts?
So most times when we have cases to kind of narrow it down to medical malpractice cases, we will have our outside counsels to give us a range of experts, or sometimes we'll even look at experts we've used before that have been successful for us, or we feel successful, and we'll normally choose based upon the CV or based upon the reputation of the expert with outside counsel. But we normally allow our outside counsel to present us with that first list. And as we were talking before, at the hospital, the type of hospital I work at, we do have people that are experts in the field, but we never use them in our own cases, but we do go over some of the details of cases so that we can get some of the blind spots that even the experts that we hire might have missed, to kind of give the attorneys, the outside attorneys, we present before the board in a legal forum and this confidential meeting where the attorneys love it because they can get feedback from all these people that deal with the exact same types of issues every day. And they can point out things that, even our attorneys haven't thought about before because they deal with those things. So there's kind of an internal expert review that helps to shore up the case.
Yeah, that's great. That sort of connection and working between outside and in-house counsel really closely in selecting the experts, I find is also sort of a best practice, because sometimes from an outside counsel's perspective, your in-house folks, your in-house contacts, they often have either they may have, a really good idea in terms of an expert, or if you have a good idea in terms of an expert that you want them to consider, there may still need to be some internal vetting of that person and, kind of discussions before proceeding.
It's also amazingly effective when we do those meetings to identify trends. I mean, a lot of times we kind of bring cases that are similarly situated. If it's all EMS cases, or maybe a lot of mother-baby cases, or whatever type of cases, then we can see, oh, I see what's happening. Or the experts in the room can identify some of the deficiencies to help us to give a better product out. Maybe there's another form we need to do. Maybe there's another step in the process.
Right.
Or maybe this is a trend overall. That this is happening everywhere. And they would know that more than we would, and they share that information. It helps a lot with the cases.
Yeah.
Yeah.
Last topic that I thought it'd be interesting to get your perspective on, and this is something that can happen sort of at any point in the life of a litigation matter, is mediation, trying to reach a resolution. It can happen before you file. I've even resolved cases while the jury is out, that's pretty late, or sometimes even after you get a jury verdict, there can be, settlement discussions and even mediation, because there's a broader context in which this one dispute sits. But from an in-house perspective, how do you approach mediation?
So normally with mediation, I will go down and speak with the general counsel. Sometimes the risk manager nurse that's assigned to the case will come as well, and we'll get some authority for settlement based upon our reserves of what we think the value of the case is. And sometimes we don't normally share our number with our outside counsel or with anyone. But normally they kind of know, if they've dealt with us before, they kind of know the range of what we're looking to sell the cases for, and we are always present. And one thing that we've started doing probably in the last 5 or 6 years is making sure, particularly in medical malpractice cases, is making sure the family is being heard and they understand that we did not anticipate the outcome. We apologize for the outcome. We did not want your loved one. Whatever happened, it wasn't anticipated. But sometimes there are unanticipated outcomes, which are not necessarily below the standard of care. So to just hear that person and to make sure they realize that we're a real hospital and, we do a lot of great things here. That's a part that we've started to put in our mediation, statements and through outside counsel. And if I go, or if my general counsel goes, or risk manager, for us all to introduce ourselves and kind of go around the room and let them know that, I know we're on opposite sides of this issue, but this is not what we want to happen to your loved one, kind of thing. And that goes a long ways. And sometimes with mediation, it gets us closer. We may not resolve it that day, but we kind of know the range. And, a couple of months later, or maybe a couple of weeks later, it's kind of softened up things, and we can go and take another bite. And sometimes those things go to resolution.
Yeah, that's an interesting point. Also that you just made at the end, in the kind of cases that I manage, we do often have mediations, but I find that they are often a step in the process, and even a case that might ultimately get resolved, maybe in shortly before trial. Um, the fact that we went through mediation before, even though it didn't resolve during the mediation, actually laid important groundwork between the parties to getting to an ultimate resolution. And sometimes I find mediators, they really want to put a notch on their belt. I've resolved this one, but that's not always what we're looking for. Of course, we're looking to resolve the dispute, but we're also realistic going into the day. And if there's movement, if there's meaningful movement between the parties, sometimes that's as much of a victory as you're going to get that day. And then you kind of, everybody kind of goes back to their corners, as it were, and continue on with discovery or preparation for trial. And it's just, it'll happen on a different day.
And it kind of tied up, it kind of goes back to what we originally started talking about, which is pre-mediation. In a couple of mediation cases I've seen, where there's one in particular that stands out in my mind, that the physicians were very communicative with the family. They spoke to them every day. And then when the unanticipated outcome happened, they stopped speaking to the family, avoided the family. And the family just basically want to know, what happened, why you're not talking to me. And sometimes you don't know. And we tell our providers, sometimes you have to say, we don't know what happened, but we're looking at it and we're going to figure it out. We're going to come back to you. But that avoidance really caused us some problems later on down the road, because the providers behave differently to the family and they could kind of feel something was wrong. And that I guess not pre-litigation, but before the dispute even happened, if things had gone differently, I'm pretty sure the family might not have even pursued it if the doctors had sat down and talked with them.
Because they would have felt differently about it.
Heard, right, exactly.
Yeah. Well, this has been a great conversation. Really interesting to kind of hear the different approaches. So thank you.
Sure. Will I see you in New York next year? That's where the meeting is, right?
I plan to be there at the In-House program in New York for 2026.
Okay.
How about you? Will you be
there? If my general counsel allows it, I'll be there. I think he will, though. He always encourages great program.
Very good. Well, I will see you there. Hope the folks in the audience get to go as well. Thanks so much.
Sure. Take care.
You as well. Bye-bye.